Well, thanks everyone. I'm honored to be here today. And my role today is to give you a really quick overview of Colorado water law. So to do that, I'm going to kind of start with the basic points, kind of what you need to know, key terminology, and we'll go through that. And then I'm going to talk about the water court process. So kind of key players, who's who, why would you go to water court? What does a water court do? As you can imagine, and maybe some of you already know, water law is pretty dense. So this is by no means a comprehensive overview of water law. It's just really kind of what you need to know to frame, when somebody talks about water law, how do you think about it and how does it work in Colorado? And that being said, I'm totally open to questions. So if you have questions while I'm talking, put them in the chat, or, I think there's time built into the program that I can answer those questions. So I will go ahead and get started. And I always like to start when I present to a group of people with varied experience with a map of Colorado. And this is kind of a fun graphic, I think, that just kind of gives you an overview of the different river systems in Colorado and some of the main tributaries, just so you can orient yourself when we're talking about some of the issues that we see locally and statewide. And I was just saying to Jayla that it seems like there's a really good, diverse group of people throughout the state. So I was really excited to see that because I think it's important when we talk about water. It's definitely a statewide management issue, but there's a lot of local management that needs to be done too. So let's get into it. What is a Colorado water right? I think fundamentally, a Colorado water right is the right to put a portion of the public's water resources to a beneficial use. And I'm going to keep bringing it back to beneficial use today as we're talking about water rights and water law. That to me is the fundamental component of a Colorado water right. You can't have a water right if you don't have a beneficial use for that water. So you might ask, well, what is a beneficial use and how do you know if you have one? So we'll get into that in a few minutes. But before we do that, I kind of want to just explain the legal framework for Colorado water rights. A water right in Colorado is established by both the Colorado Supreme Court and some of its early decisions, and the concept's embedded in the Colorado Constitution. So it really is a constitutional right that you have in Colorado to appropriate unappropriated waters of the state and put that water to a beneficial use. Sometimes you'll hear people talk about a Colorado water right or Colorado water law as the Colorado doctrine. And that's kind of a fancy way of saying that we use the prior appropriation system to manage and to understand water rights. So I'll talk about that in further detail in a few minutes. One thing I want to mention is that in Colorado, water right is a separate vested property interest that is not tied to land ownership. So there are some rare exceptions, but for the most part, you can sever water from the land and sell and convey both separately. As I mentioned, a water right is the right to beneficially use water. And that's what can be changed. So sometimes you'll hear people talking about changing the use of a water right. And what they're really talking about is changing the portion of a water right that has historically been put to a beneficial use. Sometimes this is referred to as the transferable yield of a water right. And the last thing I'll mention is that the priority date of the water right is really what creates a way to administer and enforce a water right. So priority really becomes important when water is scarce. When it's raining a lot and the rivers are flowing, people don't really focus on their priority of water because it doesn't really matter. Everybody is diverting what they want to divert and can use it for what they want to use it to. But really in Colorado, the priority system is what creates our administration, enforcement, and reliability during times of scarcity. You kind of know how much water you can get during a drought and hopefully be able to plan around that. So I'm going to move into some basic water law concepts. As I mentioned, in Colorado, the prior appropriation system is kind of the framework of our water laws. And again, the purpose of the priority system is to provide a way to allocate the public's water resources when it's scarce. So that's really the goal of using the prior appropriation system. Sometimes you hear prior appropriation referred to as first in time, first in right. And what that means is the most senior water right, so with the water right with the earliest priority date, trumps all other rights on the river system. So if you have a senior priority date, you know that you're going to be able to divert probably an almost full supply under your water right during a drought year. Conversely, if you have a junior priority date, you know that if it's a drought year, you may not be able to divert at all. So really those priority dates are all relative to each other within a stream system. And it's really important to understand when you're talking about a particular water rate, what the priority date is of that water rate and how it compares to all other priority dates within that same river system. So we'll talk more about the water court in a little bit, but the purpose of the water court is really to adjudicate water rights and priorities. As I mentioned, you have a constitutional right to make this appropriation of unappropriated water. So the water court doesn't create a water rate, it just confirms that you did actually make an appropriation of water. And the benefit of going to water court is that it assigns a priority date to your water rate, and the priority date is what can be enforced by the state water officials. So our main state water official is Kevin Ryan. He's the state engineer, and you'll hear from him after I speak. And Kevin works with the division engineers, and there's one division engineer per water division, and there's 7 throughout the state. So their role is to make sure when water is actually being physically diverted on the ground, that those diversions are being done in accordance with the terms of the water court decrees and the priority dates associated with the water rights. So I think it's kind of important when you're thinking about water supply to always ask 2 questions. First, is the water legally available? And second, is the water physically available? And you need to have a yes answer to both to really have a secure, reliable water right. I think sometimes people kind of merge both those concepts together. And so sometimes you'll hear people talk about having paper water versus having wet water. It's not enough just to have the legal right to use the water. You also need the physical supply in conjunction with that paper water right. So let's break down the prior appropriation system in a little bit more detail. As I mentioned before, it's often defined as first in time, first in right. And that really goes back to how the state of Colorado was formed. I think really, really early on, even before statehood, people kind of had this idea that water was scarce throughout the state, and they needed a mechanism to make sure if they made a diversion from the river that they knew they were going to be able to use that diversion to irrigate, and that their neighbor wasn't going to take that water when they were planning on relying upon it. So that's kind of how we came up with the prior appropriation system. Colorado has a strict prior appropriation system. It's the only state in the country with a strict prior appropriation system. I think other Western states kind of have hybrid approaches. Oklahoma is a good example where they use prior appropriation in the western part of the state, but the eastern part of the state is a lot wetter. So they have a permit system for the eastern part of the state. So there's some combinations throughout the West, but Colorado really is under the strict prior appropriation system. And it means just what it sounds. You know, if there's a drought, if a water right needs to be cut off, you look at the priority date and you decide how much water is available, and you have to fulfill the more senior water rights before the more junior water rights can divert. So appropriation, let's talk about what that means. As I mentioned before, there's this constitutional idea that you can make an appropriation of the unappropriated waters in the state. So anybody can do that. It can be an individual, it can be an entity, it can be a governmental agency. And so what that means is you have a beneficial use that you want to put a certain amount of water to. So you divert that water from a river, and that's kind of the most simple example where you make a diversion from the river and you say, okay, I've diverted 1 CFS. I want to use this to irrigate a field. And you start doing that. That's an appropriation. But the key is that the water can't be allocated to somebody else's priority date or water right. So that's when it gets a lot more complicated. It's not really now as simple as going out to the river and just diverting water. You really have to know, is there physical supply available for me to divert when I want to divert it? The case could be you may be able to get water in December, but not in July. And so what does that look like for a water right? And that's where the water court comes in to kind of define the parameters and the scope of an individual water right. And like I said, the water court also confirms that you did in fact make this appropriation, that you appropriated water that was unappropriated, and then assigns a priority date to your water right. The water court also can impose terms and conditions on the water right to prevent injury to more senior water rights in the same stream system. So that's another role that the water court serves as part of this whole prior appropriation system. Okay, I'm not going to go through all these because we've hit on some of them, but these are kind of the key water law terms that you'll hear. I think just, even when you work in water, not necessarily in the legal world, but these are kind of some fundamental concepts you need to be aware of when you're talking about water. We talked about the priority date. The adjudication date is the date that the water court actually enters a decree in your case. So you need to think about priority date and adjudication date when you're looking at a water rate to figure out how it will operate and how it will be administered. The other term I'll point out is a call. And so that's good to know because that fits into the priority system. If you are a senior water user and you want to start diverting your water, I think historically you would just call up your local water commissioner and tell that person, hey, can you turn on my head gate? I'm ready to irrigate. I want to divert this much water. I think it's done by email now, but the concept's still the same. You're basically putting a call on your water rights. And then the role of the water commissioner is to make sure that you're in priority. If you are in priority, how much water can you divert physically from the system without injury to anybody else, and to make sure that you do actually have a beneficial use for that water. I think sometimes, I don't know if anyone's familiar with use it or lose it. I think that's a thing that kind of comes up every few years, but and I think the idea there is where people are saying, oh, some water users just divert water to have the record that they made this diversion and they don't actually have any beneficial use for the water. And so I just bring it up because beneficial use is fundamental to the water right. You can't have the diversion, you can't have the appropriation, you can't have the priority date without that beneficial use. So it's really important to always think about what is the beneficial use of water. I think it's interesting when you look at the statutory scheme for water law in Colorado. It's really long. I was just looking at it's like 150 pages, the statute, and it keeps getting amended. So there's all these different subsections. But what has never changed is the definition of beneficial use of water. And I put it here, which is what I pulled from the statute, so you can read it. But I think you'll see that the legislature has always been really careful not to have an exhaustive list of what is beneficial use of water throughout the state because it's changed over time. If you think back to the 1800s, you'd probably think, okay, well, irrigation is on that list and nothing else. But now as things change and jobs change and people move to different parts of the state, I think that we understand the beneficial use of water a little bit differently. And I personally think it's good that we have this flexibility in the law to kind of define as we go what is a beneficial use of water and what's important to us now. So there's a few different general types of water rights. The first is a direct water right, which means you divert from a surface water system. And so going back to the example I gave earlier, that would be a surface stream. So like a river, you just go out to the river, get a bucket, dig a hole, like whatever you can do to get the water out of the river to get it where you need to have it to put it to beneficial use. Included in surface water, and I'm not sure if you've already talked about this, but groundwater throughout the state is presumed to be tributary to surface water. So what that means is we treat groundwater the same as surface water. So if you drop a well and it's near a river, even though it's a well and you're pumping groundwater, you basically assume that you're diverting the surface water because the stream will feel the impact of that groundwater diversion. You know, typically a direct water rate is expressed as a flow rate. So that would be in cubic feet per second. And what that would tell you how much flow you can divert at any given time. A storage right is pretty self-explanatory, but the legal definition is that it's the right to impound water in some sort of structure that can do that for more than 72 hours. So there's a lot of structures, especially when you're irrigating, where you keep water in the impoundment structure for less than 72 hours, and that's not a storage right. To be a storage right, it has to be more than 72 hours. And that's usually expressed in an acre foot amount, with a flow rate to tell you how fast you can fill the structure. Colorado is unique in this regard where we have a statutorily recognized in-stream flow rights, which are rights that can only be appropriated and held by the Colorado Water Conservation Board, the CWCB for short. And so the point of an in-stream flow water right is really to preserve the natural flow in any stream or river basin throughout the state. The in-stream flow statute was passed, I think, in the mid-1970s. I don't have the exact date in front of me, but kind of as part of, you know, a nationwide movement to focus on the environment and kind of preserve our natural environment. That being said, in-stream flow water rates are still given priority dates by the water court, and they're administered within the priority system, just like any other water right. So that's how those work. I think, you know, in my experience, you see in-stream flow rates more commonly on the western slope of the state. I don't think there's too many in the South Platte River Basin, for example. Kind of similar to an in-stream flow rate is a recreational in-channel diversion rate. Sometimes that's referred to as a RICID for short. And so that's a water rate that can only be held by a governmental entity. And the point of that water rate is basically to create whitewater rafting parks in rivers. So what the governmental entity will do, and usually it's a town or city who appropriates RICIDs, they'll go out and, you know, they'll put stones in a river, they'll try to build like a waterfall thing just to make it a recreational experience for the boaters. It also serves the purpose of keeping a certain amount of flow in the river as well. And then the last water rate I'll mention is called the federal reserved water rate. The most common example of this is tribal water rights. And the idea is that when the federal government created reservations, even though they didn't actually reserve any water for the tribes expressly, we kind of imply this concept that, of course, the government wouldn't have created a reservation without intending for the tribe to have a certain amount of water for what they needed to use on the reservation. I think it's kind of a hot topic always. It's kind of interesting how we think about these reserved rights, not just with the tribes, but there's other types of federally reserved rights for national parks, for example, for monuments, forests, things like that, and how they kind of fit in to the prior appropriation system. The interesting thing about tribal rates is, for the most part, they're unquantified. So nobody really has a great sense of how much water the tribes have. And it's kind of like a super water right, like the most senior water right you could think of. So they're always entitled to use the water that they need to accomplish the purpose of their reservation. But it's hard to fit it into our system that's so focused, at least in Colorado, on quantifying water rights and what is the priority date and when are you going to use what and how is it going to work. So it's kind of like this it's a big amount of water, I think, but nobody really fully understands how it would fit into the state's administration, particularly if there were a compact call. So the classic example is if there were to be a compact call in the Colorado River compact, how would we treat the tribal rights? What would that look like? The tribes weren't a part of the 1922 compact negotiations. So is it fair? Are they bound to the terms of that compact, or would it be something different? I don't know the answers to these questions, but these are kind of some hot topic questions floating out there regarding reserved water rights. Okay. So I'm gonna, I just mentioned the Colorado River Compact. So I'm gonna talk about interstate compacts and the doctrine of equitable apportionment just for a minute. I think when you think about these concepts, they're distinct, but they're similar. So an interstate compact is if you have a river system that crosses state lines. That means the states sat down, they came together, they decided how to allocate that water and what it would look like, and they came to an agreement that was approved by Congress. So that would be an interstate compact. Equitable apportionment is done by the United States Supreme Court. And it's the same circumstance. You have a river that crosses state lines, but the states cannot agree. So there's no compact. They can't agree who should get what. So then the US Supreme Court has original jurisdiction over the matter. And they usually appoint a special master, which is typically somebody with water knowledge or expertise who figures out which state should get what and how it should work. So those are kind of the two ways that interstate rivers can be allocated among states. Colorado, as you probably know, is the subject to many interstate compacts. I'm sure Kevin would be able to tell you the number. I think I'm gonna say it's 7 or 8, but I could be wrong about that. But the bottom line is Colorado only consumes about 1/3 of the water that its rivers produces due to all those compact obligations. Okay, so I know that was really quick, but that's kind of my 20-minute overview of water law. I don't know if anybody has any questions now, or I can just jump into what water court's all about. Okay, so let's talk about water court. So there's 7 water divisions in Colorado, and those are based on major rivers throughout the state. So you can see them on the map. These are the 7 major river basins that we have in Colorado. Each water division has its own water court. As part of the water court, you have the water clerk, the water referee, and the water judge. As I mentioned earlier, each division has a division engineer who is overseen by the state engineer. And each division has water commissioners that work underneath the division engineer. And this is just another graphic. So you can see that each larger division has different districts. So these would be kind of the tributary systems to the bigger river in each division. And the water commissioners, usually you have 1 or 2 water commissioners per water district in the water division. I know it's a lot of divisions and districts, but okay. So why would you want to go to water court? As I mentioned earlier, water courts do not create or grant water rights. What water courts do is confirm that you did actually appropriate water, you actually have a beneficial use for water, and confirms the priority date for that diversion. So you don't ever need to go to water court, except for some limited circumstances. You know, if you're fine just making your diversion from the river and nobody's bothering you, you can do that. You don't need to go to water court. But the issue is if you want to enforce that diversion. So if your neighbor takes what you think is your diversion, or if it's a drought and you want to call the water commissioner and ask, hey, can I divert X amount of water? In order to do both of those things, you need to have a water court decree that confirms, like I said before, the priority date, the amount of water you can divert, when you can divert the water. and any other, the point of diversion for the water, where you can use the water. So the water court really creates the enforceable water right. So I'm not going to go through these slides in great detail, but this is just more for your reference. This is kind of the who's who of water court. I mentioned there's a water judge. Water judges are also district court judges. So typically they hear water cases in addition to their regular rotating docket of criminal, civil, family cases. All trials in water court are bench trials, meaning there's no jury trials in water court. It's always just a trial to the judge. The water referee works underneath the water judge, and the water referee is kind of the first person that you see when you file something in water court. The role of the referee is really both to factually and legally investigate the claims in a water court case, and to see if there's opposition to the water court case, to see if there can be some kind of resolution to that opposition without having the case go to trial. Another big part of the water referee's job that I like to mention is that the water referee is tasked with by rule and statute with assisting parties who don't have attorneys with the water court process. So one thing the referee is required to do is to do all the pleading drafting for parties without attorneys, and to try to help them understand what's happening in water court and how they can achieve their goal in water court. And then the water clerk is kind of the person who manages the filing and assists the referee and the water judge. And then I think we kind of fully talked about the division engineer, but I always think the division engineer is kind of the technical side of things. You know, the water referee and the division engineer usually work pretty closely together, and the division engineer is a great check on what the court is entering. The engineers can say, oh, no, that would never work physically, or, you know, what you wrote doesn't make any sense, and the water commissioner doesn't know how to operate it. So that's kind of how the court and the division engineer's office works together. And this is just a flow chart, just for your future reference of kind of the steps of a pretty typical water court case. And so these are some examples of common water court decrees that you might see. And I'm just going to talk about the first one, which is a plan for augmentation. So that is not a water right. So if you need a plan for augmentation, you have to have the water court approve a plan for augmentation. And I think the simplest way to describe a plan for augmentation is that it allows a junior water right, so a water right that couldn't really divert because it has, let's say, a 2022 priority date. It's never going to be in priority. It allows a junior water right to divert, and it provides kind of this legal mechanism for that diversion to occur by providing replacement water to the more senior water rights, so that we can achieve this maximum beneficial use of water. And I'll give you an example because I think this is kind of a hard concept to understand. So a good example would be is if you live in a subdivision, and there's 20 homes in the subdivision, and you need a year-round supply of domestic water. And the subdivision was built in 2022. So the wells that are serving the subdivision will have a 2022 priority date. So you would get a court decreed plan for augmentation that would allow those wells to divert year-round. But what would happen is there would be a more senior source of replacement water that's either purchased, usually purchased or leased, that can be provided to the more senior water rights when they're diverting. So the wells divert, but at the same time, they provide this replacement or augmentation water to the more senior priorities. So that way, everybody kind of continues on. There's no injury to the senior water rights, but the junior uses can still occur. I think it's kind of one of those surprisingly flexible concepts too that we see within the statutory scheme governing water rights in Colorado. It can be used in a lot of different ways. And I think it does really allow people to kind of achieve, like I said, this maximum beneficial use of water. So even though we have this strict priority administration there are ways that more junior uses and more junior water rights can still happen within our structure. And then the other type of water court decree I'll mention is a change in water rate. And this you have to come to water court to do too. You can't just change decreed water right on your own. And so a change would be if you want to change the amount of water, the type of use of water, the point of diversion of the water, anything about the underlying water rate, you have to come to court and basically present your case to the court, show the court, and if there are any opposers in the case, how changing the water will not injure any other water rights on the system.
Susan, about 2 more minutes.
Okay, perfect. I think this is my last slide. So these are just some resources that you can rely on if you want to learn more about water law, or if you kind of want to investigate the water court system. Excuse me. I think these are just good resources that are out there that can help you gain a better understanding of water law and water courts in Colorado. All right, that's all I have. Thank you. Thanks for your time. I appreciate it.
Great, thank you. All right, let's get our hands raised if you have questions for Susan. Thank you for that wonderful overview. It's so complicated. All right, Allison, you're up first.
Thank you. So you talked a little bit about water court and why people go to water court. So as a municipality, we actually end up there kind of a lot because we're dealing with situations where we are changing the water rights. But the other thing that happens is the adjudication of the amount of water that we expect to be purchasing when we're purchasing water rights. So how does that work? Like, how do we know for sure, or how does the court decide if we're actually right in the amount of water that we think that we are entitled to on the basis of the previous adjudications? Or do they change it? Do they say, oh, it used to be that much, right? We're in the situation we're in right now with the Colorado River. Well, you used to have that much water, but you don't anymore. So does that happen in water court as well?
Yes. So I'll start with your last point. That does happen. So anytime, and I think you're talking about an example where you need to go to water court to change something about an existing water right. So when you do that, that reopens the old case for the court and any opposers. So you basically can reconsider everything when there's any sort of change, which makes sense if you think about it in the context of the bigger system. The fundamental goal of the water court is to prevent injury to other water rights. So that's kind of the applicant's burden of proof. You have to show the court is more likely than not, by a preponderance of the evidence, that you're not going to injure a more senior water right by either your change or your new adjudication, any of those things, that you're going to prevent injury. And there's a lot of different ways you can do that. You might be familiar with terms and conditions in a decree. That's one way that the court can say, okay, I'll let you divert this time of year, but you have to measure it. Or if the stream gets below this point, you can't take your diversion because it'll harm this other water right. So those are examples of ways that the court can prevent injury to the water right.
Thanks, Susan. Jason.
Well, thanks for that presentation. It was very helpful. One of the things that you had said is that within the definition of beneficial use is fire protection. And I'm curious, when water is used for fire protection by like a helicopter, for instance, dipping into a lake, how would from a legal perspective, how would we be expected to account for that water that's used without having an accurate way to determine the amount of volume that is removed from that lake?
That's a good question. And the answer is there's no way to account for it. I think for the most part, when there's been, and I think we have to look at it on scale. If it's a really large wildfire, just locally, when the Lake Christine fire was burning, I think in 2018, near the town of Basalt, it was a huge fire. So the firefighters were pulling out a Rudeye reservoir. And so Rudeye stores I don't know, Denver's water, Aurora's water, West Slope users water. So there's a lot of different water accounts in Rudai, but when there is a fire and people are using it for firefighting, I think it's just been historic practice in the state to kind of just not worry about it and try to paper over it if it's a huge amount of water. So there's no real formal way to deal with it, but I've never heard of anybody saying, no, you can't use that water because it's not decreed for fire protection, or, you're not accounting for it.
Okay, thank you.
Thanks, Susan. All right, Dana.
Hi, thanks, Susan. So I have two questions. The first, if you said there are 7 state engineers who go around checking that water rights are being used correctly, and this just seems like not many of them for the whole state. And I was curious, like, what's the scale of water rights and how are they monitored that they're being used correctly? So I'll leave it to one question for now.
Okay.
I have time.
Yeah, no, that's a great question. And I mean, I think the short answer is there's way too many decreed water rights for the state officials to check on every water rate. And just to clarify, so each of the 7 water divisions has one division engineer, and water commissioners work under the division engineer. So the water commissioners, I'm trying to think how many the Colorado River Basin has. I think there's probably maybe 10 water commissioners for the whole Colorado River Basin, which still is not very many. And they're the ones who go out in the field and check the head gates and kind of report back to the division engineer. I'm sure Kevin can talk a little bit more about this, but in my experience, it's usually when somebody complains that the water commissioner comes out. So a neighbor will say, hey, I'm not getting my water and I was supposed to, and they call the water commissioner, and then the commissioner will come out and kind of check what's going on. I think in every local area, there's kind of like known issues with certain water users. So I think the water commissioners might have a closer eye on how those diversions are being managed. And now I think it's fairly common for some of the bigger water users to have electronic reporting data. So their head gates are done electronically. So nobody has to physically go out there and measure it. It just kind of gets uploaded into the state system so they can check how much is being diverted.
Great, thank you, Susan. We have time for one more question before break, and then Ariel, Stephanie, and Dan. Susan's going to stay on for Kevin and Bob's presentation, so you can try and get your questions in there. So Ben, go for it.
Yeah, I just had a question. As things get more efficient, say somebody goes from flood irrigation to side rolls or to a pivot, is there under Colorado water law adjustments for that efficiency or water saved? Where does that end up? Is that out to the river? Curious of how that works.
It's a good question. It's a complicated issue, but the short answer is there's no adjustment. So even if you're more efficient in your irrigation, as long as you're irrigating under your existing decree and you don't have any need to change anything, there's no real adjustment made. The adjustment would be if you want to change something and you have become more efficient over time. And so I guess I'm assuming that you're diverting less water over time. When you come to water court to change something about that underlying water right, that's when the court's going to look at how you historically use the water and how you put the water to beneficial use. So it's not the decreed amount of water that governs, it's the actual portion of the water that you beneficially use. So you could have a decreed amount of 100 CFS, but if you only use 50 CFS for irrigation, that's kind of the portion of your water right that you can change. So I realize that creates a little bit of a catch-22 situation where you want people to be more efficient with irrigation, but I do think there's a risk, that you might, if you're changing your water rate, you might take a hit on that when you come to water court. I think, in recent years, the courts and everyone else has kind of had, I think, more nuanced thinking about it. So I think there's a ways you can adjust for that. But that's kind of the simplistic answer of that issue.
Thanks.
Great, thank you.